It was a politically orchestrated agenda which was executed diligently under the guise of following the constitutional process.
You say that this was politically motivated and she was removed because she was perceived as being NPP. But those who criticize her and support this process also argue that her actions and inactions prior to the petitions coming for her removal proved that she was doing another party's bidding. For instance, the issue about the 4 MPs in Parliament, when the Speaker ruled that as long as per Article 97(1) among others, they had declared their intentions plus all the other details that came with it, they had vacated their position even before Parliament could have the opportunity to fully exhaust this process. As you're aware, Apenyomake, now the minority leader, had taken the case to court, and immediately the CJ came in and ruled that it was only the Supreme Court that had the exclusive right of interpreting the Constitution, and said that the Speaker of Parliament had no right within its own parliamentary executive. You do not think that those who say that she herself had proved herself political, leading to her removal, all right?
In order to appreciate this matter properly, it has to be situated in 2 important perspectives. The first perspective being the legal perspective, and the second perspective being the political perspective. I'll start with the legal perspective of the whole matter. So, Madam Gertrude Torkornoo, Justice Gertrude Torkornoo, filed an action before the ECOWAS court to seek certain human rights claims. The action before the ECOWAS court was not to determine the constitutionality or otherwise of her removal, was not to justify her removal. The action before the ECOWAS court was to claim the fact that her fundamental human rights to dignity, her fundamental rights to fair trial, and other stipulated rights under the African Charter and recognized international laws have been infringed upon or have been breached. And so she sought the jurisdiction of the ECOWAS court to deal with these human rights matters. And so the conversation as to the fact that the decision of the ECOWAS court validates or justifies the removal of the CJ, in my humble opinion, I do not think that it is right for anybody to allude to that fact. You can say that the ECOWAS court has vindicated the fact that her rights were not breached, but to say that the ECOWAS court has vindicated the internal processes, I do not think that, because in any case, the ECOWAS court, largely, we know that Ghana is a sovereign nation. The ECOWAS court does not have the legal mandate or jurisdiction to determine any matter that happens in this country, to determine the constitutionality of any matter that happens in this country. That doesn't lie within the jurisdiction of the ECOWAS court.
But aside from the human rights aspect, the ECOWAS court also talked about the procedure, because Madam Torkornoo said that even the committee was not constituted properly, she didn't have fair hearing, among others. And the ECOWAS talked about the procedures. The court said that the procedure was fair. It talked about a single petition being used to remove her, saying that it wasn't irregular and all of those.
That's the same thing I'm
saying. Comment on it.
We are talking about the same thing. I'm talking about the constitutionality of the process. Let's not forget some, legal persons have raised concerns regarding the constitutional process. That was not the matter before the ECOWAS court. So, respectfully, let's stick to the facts. Now, Madam Gertrude Torkornoo also invoked the jurisdiction of the ECOWAS court because the domestic courts have, about 3 or 2 occasions, did not entertain her matter in the domestic court, and so she thought it was wise that she seeks the intervention of the ECOWAS court. When she filed the action before the ECOWAS court, the Attorney General sought to throw out the matter under the guise of the ECOWAS court not having jurisdiction to even hear or entertain the matter. But the ECOWAS court disagreed with the Attorney General and decided to hear the merits of the matter. I will not go into the details of the matter, particularly because the complement of the full ruling is not yet out. And so I do not know the reasons or the ratio behind the decision of the court.
But
so I would not want to jump the gun to say that the court decision is legally sound or not. But I'll wait, and then when I have the full complement of the ruling, then we can have a proper conversation about this matter.
You're saying that, if I get you correctly, are you saying that the local system or court did not entertain her case?
I'm saying that she was thrown out of the local court about 2 times, and that is a fact.
But before she went to ECOWAS court, the argument was that she was supposed to have exhausted all her processes.
And I'm saying that,
before she went
was she thrown out of the local court?
But if you're making your argument,
no, I'm asking a question. You can educate me if I'm wrong. Was she thrown out of the local court?
When you present a case to court, the court looks at the merits, and it can choose to either retain what you've brought or throw it out.
Absolutely.
But if
I'm saying she was thrown out.
Yes, if the court throws you out, are you trying to say that it was just the court's decision not to entertain her case rather than
you are mixing what I said. I said when she filed the action before the ECOWAS court, it was the case of the Attorney General that the ECOWAS court should not even entertain her matter.
Okay.
And then I came down to say that she was thrown out of the local court twice. And that is a fact. That is a fact. Now, considering the political perspective of this matter, on my way here, I was listening to you. You earlier mentioned that the removal of Justice Gertrude Torkornoo was a political promise. Nobody can run away from that fact.
So forgive me. What I'm trying to say is that before you go to the political arguments bit, what I'm saying is if you go to court and you don't have what you have to present, the court will obviously throw out your case. We've heard Andy Appiah Kubi complaining about how he doesn't think that the court is serving him right in his case with Mundi. So I'm trying to let you know that the name of the game is evident. You don't agree with that as a lawyer?
You see, what you are saying, what you are saying is not different from what I said.
No.
The point I'm making is that Madam Gertrude Torkornoo went to the domestic court and she was thrown out of court. Is it not the same thing as what you are saying?
No.
When you go to court, it's either you succeed or you don't succeed. There is no middle ground.
The understanding I'm getting
and the point is that she was thrown out of court. Your understanding is different from what I'm saying, respectfully.
So you're not
and so if you allow me to make my point, I'm sure we would have a very good conversation.
I'll let you come in. You're not saying that she was thrown out because of whatever reasons other than evidence.
That's I am saying that she was thrown out of court. Whatever interpretation you put to it, it's up to you. But the point I'm making is that she was thrown out of court. And it is a fact that she was thrown out of court. Now, considering the political perspective of this matter, like I was saying, when the NDC were in opposition, one of their major political promises was to overhaul the judiciary by sacking the Chief Justice.
I don't remember any
right
NDC
from the outset, saying
they were going to sack a
Mustafa
CJ.
Gbande, their Deputy General Secretary, said that you can cross-check. Right from the outset.
Where did he say that?
Right from the... In fact, I think he even said it on this very platform. Right from the outset, it was their campaign promise that Madam Gertrude Torkornoo was not fit to be a Chief Justice because they perceived that she was aligned to the New Patriotic Party. They went on to tag her as Osonomame, tag her as the women's organizer of the NDC. Clearly, even the physical posturing of the then candidate of the NDC against Madame Torkornoo was actually glaring. And so it was a political promise which was well orchestrated and executed when they want power. Nobody can run away from that fact. And you see, I am very saddened. I am very saddened about why did she go to the ECOWAS court?
I'm asking you, the ECOWAS court has ruled.
Why did Madam Gertrude Torkornoo go to the ECOWAS court?
Please answer my question. I'm saying
if she wasn't suspended, would she have gone to the ECOWAS court? If she wasn't suspended, would she have gone to the ECOWAS court? And so it was politically calculated and executed. Now, I am very saddened by all that is happening to Madam Torkornoo. And I am sad for one good measure that today it is Madam Gertrude Torkornoo. Tomorrow it may be somebody else. You see, politicians, I have always maintained that politicians can do our politics. Let us be very careful not to introduce the judiciary into our politics. Let us be very careful not to target the judiciary in the course of our politics. Because the very moment we do that, we are trying to undermine the constitutional supremacy that we all enjoy in this country and the democracy that we enjoy in this country. Granted, without admitting that Madam Torkornoo was removed through the constitutional process. There are times where governments engage in what is described as constitutional terrorism by manipulating provisions of the constitution to suit a certain political agenda. And that is constitutional terrorism. And that is what we witnessed with the removal of Madam Gertrude Torkornoo. Nobody can convince me that Madam Gertrude Torkornoo's removal was grounded in law and not politics. Everything about her removal was grounded in politics. It was simply politics and nothing else. But for politics, she wouldn't have been removed. How do you remove a whole Chief Justice of the realm under such flimsy allegations? Flimsy allegations. Terrible allegations. How do you remove such a chief justice under such, you know, and right from the outset, right from day one, Madam Gertrude Torkornoo was of the position that she wasn't even allowed to cross-examine these people. On my way here, I heard Honorable allude to the fact that even in our criminal jurisprudence, when a prima facie matter will be determined before you be allowed to open your defense. Before a prima facie is determined in our criminal jurisprudence, the accused person is allowed to cross-examine the witnesses of the prosecution. And the Supreme Court has held in a number of cases that the cross-examination process is to enable the accused persons put their case across even before they open their defense. But in such a process, in such an important process of removing the CJ, if the CJ is not afforded the opportunity to cross-examine his accusers, then what kind of theater are we witnessing?
Is that what is spelled out when it comes to the removal of a CJ in Article 146?
No, I think that, you see, you gladly recognize or appreciate the fact that Article 146 in its entirety is not exhaustive when it comes to the removal of the CJ, because it gives the committee a lot of powers. And that is why I was of the position that if you look at Article 146, if you look, absolutely,
and that's what was used.
And I'm saying that as part of natural justice, as part of the processes of seeking the truth, as part of the processes of accountability, as part of the processes of transparency and fairness, it is only sound and right and reasonable that an accused person or a person accused of committing stated misbehaviors is allowed to cross-examine his accusers. It's allowed to cross-examine his accusers. You don't hold the removal, the committee sitting of a removal of a Chief Justice at a national security installation close to where the Chief Justice uncle was murdered and buried. You don't do that. When you do that, you are doing what they call psychological ops. You are psychologically manipulating the thinking of the person. What people describe as mindfuckery. That is what they did to the Chief Justice. That is what they did to the Chief Justice.
It didn't think so.
You see, it is even an embarrassment that this matter got to the ECOWAS court. It's an embarrassment. I think that it's a total embarrassment. But then again, I mean, the president has decided to do what he wanted to do. The Chief Justice has been removed. Whatever conversation we have here, the Chief Justice will not be reinstated. And so I think that it is an embarrassment to our democracy. It is something that should never happen. It's an assault on rule of law and constitutionalism. Let us not embrace these acts of constitutional terrorism and constitutional lawlessness, using the law, manipulating the law to favor a certain political agenda. Let us not encourage these acts, because these acts have the tendency of destroying the very democracy that we enjoy in this country. And so the removal of Madam Gertrude Torkornoo was grounded in politics. It was a politically orchestrated agenda which was executed diligently under the guise of following the constitutional process.
You say that this was politically motivated and she was removed because she was perceived as being NPP. But those who criticize her and support this process also argue that her actions and inactions prior to the petitions coming for her removal proved that she was doing another party's bidding. For instance, the issue about the 4 MPs in Parliament, when the Speaker ruled that as long as per Article 97(1) G, among others, they had declared their intentions plus all the other details that came with it, they had vacated their position. Even before Parliament could have the opportunity to fully exhaust this process, as you're aware, Apenyomake, now the minority leader, had taken the case to court. And immediately the CJ came in and ruled that it was only the Supreme Court that had the exclusive right of interpreting the Constitution, and said that the Speaker of Parliament had no right within its own parliamentary executive. You do not think that those who say that she herself had proved herself political, leading to her removal, are right?
What is the job of the CJ, if I should ask you? Do you know the job of the CJ?
Go ahead and make your point.
The CJ has two duties as the Chief Justice. One, the first duty is an administrative duty that has to do with empaneling and other things. The second duty is that she herself is a Justice of the Supreme Court.
And so you agree with that decision?
Let me make my point. You've asked me a question respectfully.
Go ahead.
And the second duty as a Justice of the Supreme Court is to administer justice. Now, we all know it's a matter of law and fact that when it comes to the interpretation of the Constitution, it's the sole jurisdiction of the Supreme Court. Even the High Court does not have the power, or the Court of Appeal does not have the power or the powers to interpret any provision of the Constitution. And so, from what you have said, that the Speaker of Parliament sought to interpret provisions of the Constitution, that is not the job of the Speaker of Parliament.
He wasn't interpreting, and
you said the Speaker of Parliament was interpreting the Constitution, and that is why the learned Honorable Afenyo